But Aditya Pratap, would you want to respond to Shashank Shekhar Jha's argument? And he makes a very solid one, by the way.
See, if you see when His Lordship, the Justice Dipankar Dutta's bench issued notice in the petition, it said that there is a major conflict of interest in allowing a lawbreaker to become a lawmaker. Section 8, as it is apparent on the record of the Representation of People's Act, clearly says that after the conviction ends, after the imprisonment ends, for 6 years he should be disqualified. However, please keep in mind the context at the time at which this law was passed. This law was passed in the year 1951. We have the Representation of People's Act 1950, and we have the Representation of People's Act of 1951. At that time, criminals in the legislative bodies and the parliament used to be an exception rather than the norm. But as the figures given out by you indicate, that now criminals in politics has become the norm rather than the exception. So which is why, what is the object of the law? The object of the law is deterrence. Because ultimately, as the saying goes, that be you ever so high, the law is always above you. And when you allow a person with criminal antecedents to contest elections, because see, what is basically, because try to understand that when a person serves out a sentence, he regains his freedom. But then public office is a privilege. You are giving that person several parliamentary privileges. You are giving him the power to make law, so the point is, the court, it is within the freedom of the jurisdiction of the court, and especially the Supreme Court also has inherent powers under Article 142 of the Constitution of India to even entertain this petition and pass substantive orders where it feels in cases where justice would not adequately be served. Here, because the question is, if you look at the law, 6 years is the time period of disqualification. The point is, has this period deterred criminals in politics? Unfortunately not. It may serve to disqualify individual politicians, etc. But then when the rising trend is seen, it is very much evident that the number of criminals, and as you said, 46% Lok Sabha MPs facing criminal cases. So the point is, when the court decides such cases, it also sees what is the object of the law. The object of the law was to essentially ensure that criminals don't enter politics. And plus, the conflict of interest is very much evident here, because ultimately this is the same government whose bulk of any government, be it opposition, be it ruling party, when the substantive number of members have criminal antecedents, then one cannot expect a fair response from them. They are bound to oppose such a petition, and they are likely to even oppose.
This is a conflict of interest, you are saying, in any case.